Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Anora, Wang. Today's topic is, can antitrust be more innovation-centric? Economic understanding of the relationship between competition and innovation. It's widely recognized that innovation is important to economic welfare, but it has been difficult to treat innovation effects analytically, at least not as readily as static price effects have been treated. Some may also argue that at least the U.S. antitrust has failed to measure, predict, or enforce against harmful innovation effects or the reduction of those, and enforcement actions throughout history have largely been price-centric. Can this be changed with better economic understanding of the relationship between competition and innovation? What can be done with innovation using tools such as dynamic competition analysis and market definitions focused on R&D for assessing innovation impacts in merger and conduct cases? Joining me today is my co-host Panos Dimitrellos. Hi, Panos.
Hi, Anora.
Who is our guest today?
Our guest today is Professor Richard Gilbert. Professor Gilbert is an emeritus distinguished professor of economics at the University of California, Berkeley, and one of the foremost scholars on innovation and antitrust policy. He served as a Deputy Assistant Attorney General in the Antitrust Division of the U.S. Department of Justice and has written extensively on the intersection of competition, technological change, and intellectual property. His work has shaped how economists and policymakers understand dynamic competition, particularly in high-tech and pharmaceutical industries. Today, he joined us to explore how innovation challenges traditional antitrust thinking and what that means for enforcement in rapidly evolving markets. In relation to today's topic, Professor Gilbert has a recent book called Innovation Matters: Competition Policy for the High Technology Economy, and a recent call of a paper titled Antitrust for Innovation, a Progress Report that listeners should check out. Links are in the show notes.
Great. Without further ado, Professor Gilbert, welcome to the program.
Thank you for having me.
Panos, why don't you kick it off?
Sure. To start with the framing of the problem we have here, it has been argued that traditionally antitrust has focused more on price and output than on innovation. Why should innovation, which is a dynamic and forward-looking factor, play a more central role in antitrust enforcement today?
Well, thanks, Panos. It's easy to appreciate that innovation can have a bigger impact on our welfare or economic growth than prices. Compare, say, a 5% reduction in the price of a landline telephone to a cell phone. The latter has had much bigger impacts, and yet antitrust seems to be more concerned about the 5% than the innovation of new products or ways of doing business.
And in your research paper, you point out that early antitrust cases like Standard Oil in 1931 barely mention innovation. Why do you think innovation was historically overlooked, and what has changed in the recent years to bring it back to the forefront?
Well, an interesting question. Let's go back to Section 2 of the Sherman Act. Section 2 of the Sherman Act is really about market structure. It doesn't say anything about prices or innovation or output. And in fact, if you go to the early cases, they were entirely decided based on structural concerns. There's a famous quote from the 1945 Alcoa case. Judge Hand said Congress did not condone good trust or condemn bad trust. It forbade all trusts. Now, I think over time, with regard to Section 2, enforcers have become somewhat more concerned about whether there are good monopolies or bad monopolies. And particularly in the digital age, that seems to spawn, highly concentrated markets all over the place. The question is, are these good or bad? And that's been occupying us more, but we haven't really delved too hard into that question. Merger enforcement It's a little different because merger enforcement has looked at prices, not just structure, even though it started out as mostly structure oriented. And lately, enforcers have been concerned about innovation for merger enforcement, but they mostly have reached the conclusion that price effects and merger effects go in the same direction. If a merger raises prices, it also harms innovation. We haven't really addressed what happens if that's not the case.
So Panos made a important distinction in the beginning, where the emphasis is on price or on innovation. I think that has something to do with economic modeling. Given my shallow understanding of the economic models, that what we call static models is what's used, and it's focused on current prices and shares. And your view is that might be inadequate in assessing competition in innovation-heavy markets, like tackle farmer. Is that right? Can you elaborate a little more?
Sure, Nora. I think there's a presumption that underlies antitrust enforcement, which is that if markets become more concentrated, prices are likely to increase. Now, that's not written into the statute, but I think it's a motivator for a lot of enforcement actions. Now, the link between, say, market concentration and innovation is more tenuous. Innovation depends on a lot of things. It depends on the incentive to innovate. It depends on the ability to innovate. It depends a lot on luck. So, all of those things are relevant, and they're a little harder, often much harder to evaluate than pure price effects.
Going to the monopoly side of things, you have written about Arrow's replacement effect. That is, monopolies may have weaker incentives to innovate. However, courts often assume large firms are innovation leaders. That is closer to the Schumpeterian view of creative distractions. So, when does monopoly hinder innovation? When it might support it?
So the replacement effect is important. It's not the only story that's relevant to innovation. There are a lot of factors. But the replacement effect is, I think, easy to understand. It just says that if you have a lot of profits in the market, and if you innovate, create a new product, and it diverts profits away from the old product to the new product, well, that's a cost, and that's a disincentive to innovate. And it's more likely to be a cost in highly concentrated markets. That's it's not the only issue, but it's something to consider. Now, Schumpeter, good old Joseph Schumpeter, gets a lot of attention. I don't think anybody has more quotes than Joseph Schumpeter. And even though he doesn't write all that much, there's a quote everywhere. Even USB Microsoft started off with a quote from Schumpeter. But I think Schumpeter is actually misunderstood in a lot of ways with respect to antitrust enforcement. Schumpeter did not say that monopoly is good for innovation. He said that scale and stable profits are good for innovation, and that's not consistent with perfect competition. He also talked a lot about creative destruction, which is perennial gales of creative destruction, which is true. Yes, that happens. But that is not really a reason to tolerate mergers or other conduct that might raise prices before creative destruction happens, unless it's the case that the merger or the conduct makes creative destruction more likely. Otherwise, it's just something in the future that's going to change market boundaries and not necessarily be a reason to tolerate price increases. So, Schumpeter is very important. He's made a lot of great statements, but I think some of them are misinterpreted for innovation, at least for antitrust enforcement for innovation.
You think, if there are claims, if efficiencies, right? As you have made a distinction, Schumpeter is not saying monopoly is good for innovation, but scale, large scale of economy might, right? And if there is an efficiency claim in sort of like a merger, and that would increase the scale, I guess, and then you think it should be skeptical to look at those claims, or how should be credibly demonstrated that innovation related efficiencies actually exist?
Anora, I think that's the multi-billion-dollar question, because if static price concerns and innovation concerns go in the same direction, so to speak. So if prices go up, innovation goes down, or if prices go down, innovation goes up, then innovation's just an add-on to a case. It might make you more confident in bringing a case, but it's not necessarily going to change the outcome. But what happens if we have a situation where, say, prices go up but innovation goes up? How do we measure that? That's an innovation defense. And it's a hard one to measure, but I think it's even harder than the measurement problem is getting courts to do it. Even if you know how to measure these effects, I think there's a long tradition of resistance in the courts to doing this type of analysis. And that's somehow what we got to get over.
And if we want to focus on markets where innovation is central, which ones would those be? Which markets are most susceptible to the innovation price trade-off that you just mentioned, where we might see innovation and price effects pulling in opposite directions? Are tech and pharma good examples?
Well, there's certainly good examples, but there are a lot of examples. There have been a lot of innovation cases in, say, agricultural products, new media, software, truck transmissions, power plants, you name it. Tech is obvious in part because often we don't have a price in tech, and so the questions are, what are the innovation effects? And of course, it's a highly progressive, highly R&D industry. Pharma is interesting because you have a pipeline. And because you have a pipeline, you can do potential competition analysis pretty easily because you know what's going to come out of the pipeline with pretty high probability. But there are a lot of products and services and industries where there are innovation effects.
On what you just said, how common is it mergers to eliminate future R&D competition in pharma? That is there a difference between suppressing a pipeline and failing to develop a promising drug?
So pharma, is where we had a great paper called Killer Acquisitions, showing that under some circumstances, acquisitions are resulting in killing off a product or a project that's in a pipeline. But it is, and I think the paper was clear about this, it's important to realize that killing off an R&D project is not necessarily the same as killing off innovation. R&D is an input to innovation. It's not the output of innovation. So if you acquire a product, maybe kill it, but replace it with another product or focus more on another product, the result might be the same or more innovation with less R&D, which isn't a bad thing. Killer acquisitions are something to worry about, but don't necessarily mean harm to innovation.
I think maybe this is a good point to talk about R&D markets, right? You said R&D is an input and not an output. I think that's intuitively understandable. And then, but I think reading your paper, which is not easy, it is advocating actually using it as a tool to define an R&D market. So how should enforcement agencies define innovation markets or R&D markets when, for instance, no product has existed and R&D is only an input, as you said, not an output? How feasible is that under current analytical frameworks?
So the concept of an R&D market has attracted a lot of controversy, and there's a big question about whether an R&D market can even exist under the Clayton Act. Many people say, no, it's impossible. I think that really misses the mark entirely, because as you say, the purpose of an R&D market is an analytical tool. It's something to think about an innovation case. If you're bringing an innovation case, whether it's a merger or whether it has to do with Section 2 or whatever, you're going to want to ask, who are the likely innovators? Who who are we concerned about in this space? And that means defining the space somehow. Whether you define it based on R&D or capabilities, or whether you define it based on patents. For example, the Dow DuPont case basically defined an innovation markets based on patents. It's going to happen one way or the other. And however you do it the way that it's most effective for the job at hand. Whether or not it's a legal concept, from my point of view, is really not the point.
And we understand from your work that conventional antitrust tools are not always sufficient for innovation analysis. Are there any new tools that you think can be helpful and promising?
Well, we've made progress. Unilateral effects and diversion analysis has been very useful. The competitive strategy literature is trying to take a deep dive into capabilities analysis. These are emerging tools, I think, that will be helpful at some point. But we still have a ways to go. And I really think what we need most of all is some good empirical evidence. And we're beginning to get that. We just need more of it.
And thinking of this, let's assume that we're looking for the ideal kind of empirical evidence that we can use to evaluate innovation harms. How would that look like? And are those kinds of evidence used by agencies today in a good way?
Well, I think it's a complicated question, really, because, unlike price effects, sometimes, for example, in a merger case, you can get actual real-time relevant price information by looking at, say, market structures in comparable industries that differ only, in geography. You really don't get that with innovation. Tends to happen everywhere. And so you don't have what we sometimes call in econometrics a difference in difference analysis that you can do. What I'd like to see is enforcers and hopefully the courts look at a portfolio of empirical evidence that is similar to a case at hand and say, well, we know this from these cases, and it gives us confidence that this is what we should be concerned about here, even if the evidence is not exactly on point for this case. Because getting evidence, not that it would be desirable, obviously it would be desirable to have the evidence on point, but getting there may be an insurmountable challenge. So we might have to look at comparable but not identical situations.
Yeah, and as we know, antitrust enforcement approach changes from time to time. Reportedly has declined since the 90s. Do you think that this is particularly problematic for our innovation-focused industries?
Yeah, for sure. Innovation is critical, and it's coming up more and more. We have to pay attention to it.
And should enforcement agencies define innovation markets or R&D markets more often, if no products exist yet?
Well, again, whether it is accepted under the Clayton Act is not something that I think is really the important question. The question is whether, these are tools that are helpful to thinking about the problem at hand. And I think they are if they're, used properly like any other tool. It is a useful construct.
And going a bit more particular, let me bring an example about vertical mergers. So how do vertical mergers, for example, particularly let's think about platforms or data ecosystems, impact innovation incentives differently than horizontal ones?
That's a big question because, platforms raise so many issues, zero price markets, network effects, complementarities. There's the issue of ecosystems. Entrenchment is an issue in some kind of platform markets about whether, even if a merger, say, is not directly horizontal, does it reinforce market power in some other way? And does that have an adverse effect on innovation, or is it good for innovation? there are just a lot of complicated questions having to do with platform markets in particular.
We mentioned your article at the opening, and which I've read, and I think I benefit a lot from that. You talked about some very recent and even ongoing cases. So some of them are big tech investigations. Do you believe that the current, at least in the US, the big tech innovations reflect a real shift towards quote unquote dynamic enforcement priorities, right? We made this distinction between dynamic and static. But analytically, do you think the agencies or even courts who are actually dealing with litigations are actually just shoehorning dynamic concerns into static legal models?
Good question. This is my view, but I think there's some basis for it. I think the answer is that, say, with Section 2 cases at least, courts haven't paid much attention to price or innovation. And, if you look at, say, US v. Microsoft, started off, at least at the appellate decision, talking about Schumpeter and innovation, never came up in the rest of the case. In fact, they didn't even talk about price effects. They talked about changes in structure, which were viewed as sort of presumptively troubling. And if you look at, say, the Google search case, search access point case recently, I don't think that decision mentioned prices. I don't think it mentioned innovation directly in terms of reaching the outcome. Now, where innovation in these cases, I think, is likely to be more important is when they talk about remedies, because there you can't avoid dealing with the fact that these remedies could have big innovation effects, and that's where I think you're going to see it most prominently.
So I guess to unpack that a little bit, so I understand. I really sympathize. It's easier to look at number of firms, right? Or the market share, which is static and easy to count, maybe with your fingers sometimes. But it's like when you're looking forward and you're looking at potential harm, I guess, to innovation, and then there are actually consideration in designing the remedies. I think that's really the difficult is. And do you think that's where the analysis should really focus on making a difference between the static and dynamic in designing remedies?
Well, with respect to Section 2, I think that's where we're first going to see the attention to innovation, because there's this tradition in Section 2 of really not looking at market performance directly in the liability phase and more thinking about structure. But on the remedy phase, you can't avoid innovation. I think that's where it's going to get a lot of attention. Now, merger cases have been more about effects. There's been more attention to innovation directly, and prices, of course, directly on merger cases. So we might see more of that on the merger side. But on the Section 2 side, I think innovation is, maybe not only, maybe it is not going to ignore innovation on liability or prices on liability, but I think where innovation is going to come up first and foremost is on the remedy side.
Let's switch gears and focus on what lies forward. So let's assume that we are lawmakers and we can rewrite one aspect of the antitrust law to better account for innovation. Which one would you choose? Presumptions, burdens of proof, remedies, or something else?
Well, those are all important. I don't know how to decide among them. If I have to pick one narrow issue, I would say take a look more at exclusive dealing arrangements, not necessarily more restrictive or less restrictive, but to think about how exclusive dealing arrangements affect innovation opportunities. And I think that's under-examined currently. But the other issues, and particularly remedies, as we discussed, are very important as well.
Professor Gilbert, we've learned a lot from you, but not all of us are going to remember everything that we discussed. Obviously, they feel free, and they should check out your book and your chapter. But if listeners just listening to this episode can take one thing away about analysis between innovation and competition, what would be that one thing be?
So I'll tell you what has frustrated me a lot. I've been to some ABA seminars where enforcers have talked about innovation and they have literally thrown up their hands and say, we know nothing about innovation. It's just this black hole. We don't want to go down it. It's just too complicated. And that really bothers me because it's not true that we know nothing about the relationship between competition and innovation. We know quite a lot. And whether it's reading my book or whatever, but there are many articles that have been written about this. The problem is it is complicated. But my reaction is to what they're saying is we don't want to investigate. It's not that we don't know or can't know. It's saying that we don't want to investigate. And I think with more investigation, we can get to a reasonable answer about innovation effects. Now, getting courts to actually move in that direction, that can be a different issue. It's something that we only have very limited control over. But still, to say that we know nothing is just not right.
Well, that's a very good takeaway for anyone who is thinking about innovation and competition. There are things that have been filled in the quote-unquote gap of economic understanding, and there has been good literature, including Professor Gilbert's book and article. And that's a very good area for us to pay more attention to. Now, let's shift the gear a little bit. For people who are listening to this and who probably have heard of your name but not known you personally before, would you be sharing with us just one thing that people who have been only working with you professionally would not know about you?
I don't know. Well, I ride a bike a lot. And I also own a lot of bicycles because I always find a reason to buy a new bike and I can never part with my old bikes. So I'm running out of room to keep bicycles.
That actually surprised me because when you say bike, you're not just talking about casually taking a bike around office buildings. You're doing country back or something more serious, right?
If I'm not at home, I'm more likely to be on Mount Diablo, which is a mountain not too far away from where I live and has, a great place to bike.
Well, now let's go to a section called A Curious Hat.
And now it's time for the Curious Hat. So
the music is just to give us an excuse to ask you even more silly or trivial questions. The rule of the game is really simple. We're going to ask you a random question that's associated with a number between 1 and 20. You get to pick a number, but not the questions. Could you give us a number?
17.
17. The question is, if you were given $15,000 on the condition that you have to spend it all in 1 hour, what would you buy? I guess you don't have to buy anything, but how would you do?
Oh, that's really easy. I'd buy another bicycle.
You just said you don't have room for another one.
Well, it doesn't matter. It's I would keep it in my bedroom, but my wife doesn't really approve of that.
That sounds like a great investment. Now, thank you again, Professor Gilbert, for sharing with us your insights on innovation and competition. Thank you, Panos, for being a great host, and thank you, listeners, for listening. Until next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.